Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Matthew Corr, decided on June 20, 2024. Troutman, J. Generally, those convicted of sex offenses in other states must register under the Sex Offender Registration Act, SORA, Correction Law Section 168 et seq., upon relocating to New York, see People v. Toledo. While the statute requires some sex offenders to register for life, see Correction Law Section 168H, 2, those in the lowest risk category register for a term of 20 years. The issue here is whether the statute entitles sex offenders who are classified in that lowest risk category upon relocating to New York to credit for their time registered as sex offenders under the laws of other states. We hold that it does not and affirm. Defendant in each of these appeals was convicted in another state of an offense that required him to register as a sex offender under the laws of that state. Some years later, each defendant relocated to New York and was required to register as a Level 1 risk under SORA. Neither is designated a sexual predator, sexually violent offender, or predicate sex offender. During the risk level determination hearings under Correction Law Section 168K, 2, each defendant requested that Supreme Court order him registered nunc pro tunc to the date when he registered as a sex offender in the state where he was convicted of his sex offense, in effect giving him credit for the time registered in the foreign jurisdiction against the 20-year registration period. The courts denied the requests, and the Appellate Division affirmed, People v. Corr, People v. McDonald. The duration of registration and verification for sex offenders classified under SORA as Level 1 risks, other than those designated a sexual predator, sexually violent offender, or predicate sex offender, is annually for a period of 20 years from the initial date of registration, Correction Law Section 168H, 1. Defendants contend that, in the case of an out-of-state sex offender, the phrase initial date of registration plainly refers to the date the offender initially registered in the state of conviction, as opposed to the date of subsequent registration in New York. The people respond that SORA's use of the phrase initial date of registration refers to the date when an offender first registers under SORA. Although defendants also raise constitutional challenges, those challenges are not preserved for our review, see Toledo, and we therefore lack jurisdiction to entertain them. The issue before us is purely one of statutory interpretation, and we apply our well-established rules to determine legislative intent. Where the language of a statute is clear and unambiguous, courts must give effect to its plain meaning, see People v. Galindo. We thus start with the statutory text, guided by the principles that a statute must be construed as a whole and that its various sections must be considered together and with reference to each other, People ex rel. McCurdy v. Warden, Westchester County Correctional Facility. Relatedly, absent any indication of an intention to the contrary, where the same word or phrase is used in different parts of a statute, it will be presumed to be used in the same sense throughout, and the same meaning will be attached to similar expressions in the same or related statute, see People v. Bolden. Courts cannot amend a statute by inserting words that are not there, nor will a court read into a statute a provision which the legislature did not see fit to enact, People v. Hardy. The meaning of the phrase initial date of registration cannot be discerned by reading Correction Law Section 168H, 1, in isolation, and therefore we look to its use in other sections of SORA for guidance. Construing the statute as a whole, as we must, we conclude that the phrase initial date of registration refers to the date when an offender first registers under SORA. The durational requirements in Correction Law Section 168H, 1, are explicitly tied to the annual verification requirements, which are set forth in a preceding section of SORA. Specifically, Correction Law Section 168F2, sets forth the obligations that a registrant is required to fulfill by reference to the initial registration date. For a sex offender required to register under this article, on each anniversary of the sex offender's initial registration date during the period in which he is required to register under this section, the following applies. A. The sex offender shall mail the verification form to the division within 10 calendar days after receipt of the form, etc. The phrase initial registration date expressly references the offender's registration under SORA. Our dissenting colleagues appear to agree that the phrase initial registration date in Section 168F, 2, refers to the first time an offender registers after the offender is subject to New York's SORA. We understand the statute's subsequent use of the materially identical phrase initial date of registration to have the same meaning. Considering the two interconnected provisions together, we conclude that the initial date of registration refers to the date when an offender first registers under SORA, not the date an offender is required to register under the laws of another jurisdiction. Our construction finds further support in the section that immediately follows Correction Law Section 168H, which states that registration and verification as required by this article shall consist of a statement in writing signed by the sex offender giving the information that is required by the Division of Criminal Justice Services, and the division shall enter the information into an appropriate electronic database or file, Correction Law Section 168I. Because registration, as the term is used in SORA, requires interaction with a New York agency, the initial date of registration must refer to the date the offender first registers in New York. In reaching their conclusion that the initial date of registration refers to the date an offender registers in the state of conviction, our dissenting colleagues read Correction Law Section 168H, 1, in isolation. But our well-established rules of statutory construction do not require or permit us to read disputed statutory provisions in isolation. To the contrary, a statutory provision that appears plain on its face may yet be ambiguous when read within the whole of the statute in which it appears. See New York State Psychiatric Association Incorporated v. New York State Department of Health. Setting aside our dissenting colleagues' context-free interpretation of initial date of registration, nothing in SORA provides or even arguably suggests that the legislature intended for an offender's registration in another state to have any effect on the conditions of registration in New York. Nowhere is this absence more glaring than in Correction Law Section 168K, registration for change of address from another state, which contains detailed procedures for the registration, classification, and designation of a sex offender who relocates to New York from another state or jurisdiction, all without reference to the offender's registration, if any, in the jurisdiction where the offender previously resided. Section 168K does not create procedures for the SORA court to establish the offender's date of registration in the state of conviction, to order the offender registered nunc pro tunc to that date, nor to afford the offender credit for time spent on registries in other jurisdictions. Surely, if the legislature intended for the phrase initial date of registration to require the SORA court to do any of these things, there would be some indication of it in this section. Such credit, defendants correctly observe, is permitted under federal law. But this observation undermines defendants' position. The guidance of the United States Department of Justice for the state's implementation of the Jacob Wetterling Act, which first sought to create guidelines for the state's establishment of sex offender registries, explained, the federal durational requirements for registration of offenders convicted in other states are the same as those for in-state offenders' registration for at least 10 years or for life as provided in subsection B6 of the Act. If a portion of the applicable registration period has run while the registrant was residing in another state, a new state of residence may give the registrant credit for that period. For example, if a person required to register for 10 years under the Act's standards has lived for 6 years following release in the state of conviction, another state to which the registrant moves at that point does not have to require registration for more than the 4 remaining years. The guidance notes that states are free to choose to give the registrant credit for a portion of the registration period that has run in another state. It does not mandate that they do so. SORA simply does not contain such a provision for assessing whether to award credit, and we have no authority to amend SORA to create one. Defendants' reliance on the Adam Walsh Act of 2006, which replaced the Jacob Wetterling Act, is also unavailing. Although defendants correctly note that the phrase initial registration as used in the Adam Walsh Act refers to the offender's registration in the state of conviction prior to release from prison or, if the offender was not sentenced to prison, upon sentencing, the operative language in SORA predates the Adam Walsh Act by over a decade. The use of the phrase initial registration as it appears in the Adam Walsh Act thus has no bearing on the intent of the legislature that enacted SORA. We recognize that the statute, as written, may lead to unfair results in some circumstances. For example, an offender with a minimal risk of reoffense who has spent substantial time compliant with an effectively administered out-of-state registry scheme without having reoffended would seem to deserve credit for that time as a matter of policy. Moreover, the diversion of public resources and attention towards offenders such as these arguably undermines the state's effort to protect the public against genuinely dangerous offenders. On the other hand, not all state registry schemes are necessarily created equal, for example, in terms of supervision and registration requirements, and there is no specific mechanism under SORA for a court to determine whether a foreign state's administration of its registry is as exacting as New York's or the extent to which a particular offender complied with his obligations under that state's statute and remained free of reoffense. Defendants' interpretation of the statute, adopted by our dissenting colleagues, goes even further than to award sex offenders credit for time spent registered under the laws of another state. An offender who completes a required 10-year registration period in another state and then, after a period of several more years, moves to New York would receive credit for those several unregistered years. This is because SORA requires offenders to register for 20 years measured from a certain date. We and our dissenting colleagues disagree only about that date from which the registration period is measured. If the operative date is the date of registration in the state of conviction, as defendants contend, then our state has no statutory authority after 20 years have elapsed from that date to require registration even of an offender who did not consistently register during the required 20-year period. Notably, other states opting to provide credit have set forth guidelines for when credit should be awarded and have delegated rulemaking authority to the relevant agency. Under the law of Maine, for example, offenders subject to a 10-year registration period may apply to the State Bureau of Identification for day-for-day credit for the time actually registered pursuant to the sex offender registration statute of another jurisdiction, and TE Bureau may grant credit if the registrant provides sufficient documentation in accordance with any rules adopted by the Bureau. The Board of Examiners of Sex Offenders does not currently have this authority among its expressly delegated powers. See Generally Matter of Bear Garden v. New York State Liquor Authority. It is of course a fundamental principle of administrative law that agencies are possessed of only those powers expressly delegated by the legislature, together with those powers required by necessary implication. Even in a state such as Maine, where the risk level is assigned automatically, the legislature provided for the promulgation of guidance on the issue of credit for time spent under another jurisdiction's registration regime. In New York, by comparison, the legislature opted to create a board and provide it with the authority to issue binding guidelines and recommendations to the sentencing court regarding a sex offender's risk level. See Correction Law Section 168 L. 1, 5, 6. It would be wholly inconsistent with the New York legislature's comprehensive approach to sex offender registration to leave unaddressed the mechanism for awarding credit for out-of-state supervision. No mechanism is provided because no credit is due. If such credit is to be awarded, it is for the legislature to make those policy determinations, pass the relevant law, and delegate any rulemaking authority. Finally, this is not the only provision in SORA that treats out-of-state sex offenders differently than it treats in-state sex offenders. See Toledo. In Toledo, we recognize that Correction Law Section 168A, 3b, requires any person subject to SORA's foreign registration requirements to be designated a sexually violent offender regardless of whether the underlying offense is violent in nature. The result for the defendant in that case was no less absurd than the hypothetical circumstances outlined in Judge Rivera's dissent. While recognizing that this requirement, based on SORA's plain text, may well have resulted from a legislative drafting error, we unanimously concluded that we were without the power to rewrite the statute. Toledo. The same rule applies here. Accordingly, in each case, the order of the appellate division should be affirmed, without costs. Decided June 20, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.